On behalf of the entire XIM fraternity, warmly welcome you to this significant occasion as we gather here today to observe Anti-Ragging Day at our esteemed institution. Ragging in any form has no place in our campus culture. It undermines the values of respect, dignity, and safety that we hold dear. Today's event is not just a commemoration, but a reaffirmation of our commitment to maintaining a campus environment free from harassment and fear. Today, we will engage in thoughtful discussions aimed at spreading awareness and fostering a sense of responsibility among our student community. This event is a reminder that every individual here deserves to learn and grow in an atmosphere of mutual respect and support. We are privileged to have with us Dr. Satyajit Mohanty, who has graciously agreed to share his insights on. He is an accomplished officer of the Indian Police Service, belonging to the 1988 batch with a career that spans over 3 decades of dedicated service to the nation. Throughout his illustrious career, Dr. Mohanty has held numerous key positions, including Commissioner of Police for Bhubaneswar, Cuttack, and Director General of Police for Odisha. His contributions have extended across various domains, such as law enforcement, anti-corruption, and civil defense, earning him prestigious honors like the Police Medal for Meritorious Service and the President's Police Medal for Distinguished Service. After retiring from active service in 2021, Dr. Mohanty continued his journey of knowledge and mentorship. He now serves as an adjunct professor of law at the National Law University of Odisha and as an honorary professor at the Faculty of Management, Sri Sri University, Cuttack. His academic journey includes advanced studies in law and public policy, and he has authored 6 books on professional subjects, reflecting his deep commitment to the intersection of practice and scholarship. Beyond his professional and academic pursuits, Dr. Mohanty remains an active contributor to the community. He serves as the Honorary Secretary of the Odisha Tennis Association, President of the Youth Hostels Association Odisha, and President of the Alumni Association at Utkal University, Odisha. Dr. Mohanty's presence here today is an inspiration to all of us, especially to those who aspire to lead with integrity and impact society positively. We are truly honored to have him with us, and we look forward to the insights he will share. Please join me in giving a warm welcome to Dr. Satyajit Mohanty with a round of applause. I now invite Dr. V. Vijay Kumar to deliver the welcome address.
Respected Dr. Satyajit Mohanty, retired IPS officer, former chairperson of Odisha Public Service Commissions and DGP Odisha, currently an adjunct professor of law at National Law University Odisha, the invited speaker of the day. Mr. Prashant Mahapatra, the coordinator of Anti-Ragging Squad, members and professors of Anti-Ragging Committee and Squad, the deans of various schools of XIM University, faculty, staff, and my dear students. On behalf of Father Anthony R. Vuveri, SJ, the Vice Chancellor, Father S. Anthony Raj, SJ, the Registrar of XIM University, I welcome each one of you for the celebration of Anti-Ragging Day 2024 and to this important seminar on the topic, ragging is a criminal offense. Yes, ragging is considered as criminal offense in many countries, including India. Ragging is harmful on multiple levels. That includes physically, psychologically, and morally. It is a practice that undermines the core value of education, which should be about fostering growth, learning, and mutual respect. The Honorable Supreme Court of India has issued guidance to curb ragging, and institutions are requested to take measures to prevent it. The University Grant Commissions has also mandated strict anti-ragging measures. Those found guilty of ragging can face criminal charges, including imprisonment and fine, as well as disciplinary action from the institutions. At XIM University, we make sure we sensitize the students, conduct orientation talks and seminars, and work on the principle called prevention is better than cure. The objectives of all these initiatives is to create a safe and welcoming environment for all our students. By celebrating Anti-Ragging Day through this seminar talk, we, as a Jesuit institution, proclaim and say that we are against ragging, and we make sure we have zero tolerance for ragging. We strongly believe the resource person of the day, Dr. Satyajit Mohanty, will add to the mission of the university through his talk. I take this opportunity to thank the University Grant Commission's Centralized Anti-Ragging Cell, XIM University, Professor Narayan Chandra Sarangi, Dean of Xavier Law School, for getting the resource person on the board for today. Members of Anti-Ragging Committee, especially Professor Lutz Vizian, Professor Kundya, and members of Anti-Ragging Squad, Students Executive Council, Students Activities Council, faculty coordinators of UG and PG students' activities, IT team and School of Communications team for the webcast, and all those who are making this day happening. Thank you and welcome all. God bless.
Thank you, sir. I now invite the Treasurer of the Student Executive Council, Mr. Shubhendu Haldar, to come forward and felicitate our esteemed chief guest. Thank you. It is now time to begin our seminar. I invite Dr. Mohanty to take over and lead us through this important session.
Very good afternoon to all of you. Dr. Vijay Kumar, esteemed faculty members, dear students. I have a long 3.5 decades of career in the police and posted in different parts of this particular state. Also here at the Commissioner of Police in 2018-19. If you ask me honestly whether some case study about ragging, etc., I would say, not many cases would come to the police because the idea behind anti-ragging measures is essentially some kind of a preventive measure. And the institute should handle it at their level, probably when it goes beyond the mediating capacity or discipline or the the authority of the institute, then it is brought to the notice of the police. I'll just give a brief outline overview of how the whole thing came to India. And was it there? Is it a part of our culture, or it just came in the 20th century to India? And then we'll also see briefly how the things were moving till probably there was some intervention by the Supreme Court in the latter part of last century. And also because of certain incidents, many states started having their own anti-ragging laws. So that means sometime in 90s of last century, the laws also, special acts also enacted by certain states. And then again, the Supreme Court, I would say the judiciary-driven law also to some extent shaped the whole landscape of anti-ragging measures in the higher education institutes. Then we'll also examine whether ragging is an offense or ragging still remains as a crime. A little bit of a difference between crime and offense I'll also like to discuss to all of you. And also we'll also discuss how a historic opportunity was squandered very recently. I do not want to blame anybody, but probably it is an oversight. The new laws have been introduced from 1st of July 2024. Major criminal laws, all the laws have been amended. This was an opportunity probably to include ragging as an offense in the Indian law. As of now, ragging as an offense is not pan-Indian, let me tell you. Ragging as an offense are there in only 10 to 12 states which have had their own anti-ragging law. I'll come to that little later. This I just wanted to highlight that probably this new law could have had ragging as an offense. Probably we missed that. Then some kind of a question answer if you would like to ask me. I know this is 3:30 and you have a long day, and you have been asked to be here as captive audience, or maybe to make this hall full. But relax. I'm not going to give you very heavy stuff from this side. I understand, because I have been teaching in a law school. I understand the psychology of the students. So I would also like to finish it within 30-35 minutes, so that if you have anything to ask me, I'll be very happy to answer that. Okay? Coming back to when I told that whether this is part of our culture or we kind of inherited it. As I think, as I go through also some literature, I find that this is probably one of these things which we have inherited from the Britishers. Like we inherited our criminal law and most of the modern law also from the Britishers. Way back in mid-19th century, some of the criminal law were adopted, 1860, 1872 and all these things. Continues till now. Today, of course, it is changed. The name has been changed, but the contents are almost same, varying about 10 to 15%. Amendments which were required, having regard to the need of the time, because we are moving towards digital era. So a lot of digital communication and evidences are part of the new law now. That's all. Nothing much. The framework has not been changed. So as it's a legacy, British legacy, probably from 16th, 17th century onwards, the British public schools, very reputed public school, they had something known as, we call it ragging here. I do not know why ragging. It could have been fagging F-A-G-G-I-N-G, because fagging is the word used by the Britishers in the campus. And fagging to some extent was institutionalized in the public schools. In fact, fagging, the objective of fagging was that the senior would take care of the freshers, because the freshers are likely to be bullied, harassed by other seniors. So if I am a senior and I am a fagger, F-A-G-G-E-R, ragger and fagger, so I am a fagger, then I have a small group of students who are freshers. So my responsibility, that means the institute gives you that kind of a responsibility, like the anti-ragging committee or squad or whatever. The fagger was one of those guys, and he must be probably a bully, because other bullies cannot bully him also, and his subjects, those who are the freshers. So this was the arrangement, and as a result, what happened, this fagger, the senior, he started also having his own personal things. You can have my tea, you get running errand for that boy and all those things, get a book or get a pen from outside, polish my shoes. This also happened, and this was also to some extent tolerated by those schools. This was in the 17th century, and we have the Britishers, when they came, they probably had these public schools also for their own pupils to be part of those schools. And to some extent probably this system was part of the public schools established by the Britishers in India, and it became kind of our own. We adopted it also in our institutes in the 20th century. But interestingly, sometime in 60s and 70s, last century, fagging was illegal or banned in England, and it became not fashionable anymore. They say that it is no more fashionable to be a fagger or do ragging, etc. But we still continue with that kind of a tradition. Probably this is, and also the studies show that not only India, Pakistan, Bangladesh, Sri Lanka, to some extent South Africa, Malaysia, they have this kind of a ragging culture in the higher educational institutes. So probably this we inherited from the Britishers. They have already found it unfashionable, and we still continue with that. Maybe hopefully another 10, 15, 20 years, we will also find it unfashionable, something like that. This is, but what happened in the 90s, in the 90s of the last century, what happened? In some states, educations, particularly medical education and engineering, private engineering and medical education started mushrooming in India, probably from the mid-80s or 80s onwards. And these are the places where these kind of raggings were reported in large numbers. And sometimes some embarrassing situation happened. People committed suicide because of the harassment, instigation. People have been beaten to death, a couple of instances. As a result of that, the government, particularly those where these private colleges started, particularly South India, Tamil Nadu, Karnataka, even Maharashtra, Andhra Pradesh, they are the states which introduced this anti-ragging law in their institutes, in their state, because we do not have any anti-ragging law. As I told you, we inherited the British legal system, criminal law system. We have a wonderful treatise that is known as Indian Penal Code. Now the name is Bharatiya Nyaya Sanhita or something like that. There are about 300 offences. Every conceivable offence has been part of the Indian Penal Code, thanks to Lord Macaulay, who drafted it in 1836, and it has relevance today also. You name any offence, it is there. Probably in India we never felt that ragging could be some kind of an offence which requires anything more than the Indian Penal Code. So nobody bothered about, having ragging as, but ragging is very special. Ragging as an offense, in fact, if you ask me, has no place in the Indian Penal Code. So then, sometime in the 90s, all these states where these private colleges, engineering and medical colleges came up initially in India, they had their own law, anti-ragging law. Someone from Kerala, in a public interest litigation that's known as Vishwa Jagrati Mission, a private college, and they went to the Supreme Court that in spite of all these things, the things are not, getting abated. Ragging is rampant in the educational institutions, particularly the technical educational or medical educational institutes, and there must be some kind of guideline from the Supreme Court to contain this menace. And this was in 97. By that time, 3, 4, 5 states have already come up with their own ragging law. Law means offense. They have, Maharashtra, for example, in 1997, they made ragging an offense, 2 years punishment. Similarly, some other states, Andhra Pradesh also. But this particular public interest litigation to the Supreme Court, because this was not all India, only confined to few states, and the Supreme Court gave some directive. And in fact, if you see today these anti-ragging squads, this counseling, this undertaking by the students, by the parents, whatever disciplinary action are to be taken, squads being formed, freshers being allotted a separate hostel, the superintendent keeping watch on them, internal monitoring system, all are outcome of this 2001 Supreme Court directive or rulings. In that case, known as Vishwa Jagriti Mission versus central government. So thanks to Supreme Court to some extent, and Supreme Court for the first time also defined what is ragging. Normally we thought initially ragging is some kind of a practical joke maybe, or maybe some kind of a assault or calling name or some lewd remarks. It is beyond that. It is mental, psychological, physical, sexual also. So assault. So the Supreme Court for the first time defined the ragging in 2001 ruling in Vishwa Jagriti case. And what you see today, I was having a look, Professor Vijay Kumar was kind enough to share, whatever your anti-ragging celebration, your briefing or what do you call it, some kind of an induction for the freshers. What you mentioned, these are raggings, etc., are from that Supreme Court directive. Then another very interesting aspect in that 2001. In 2001, the Supreme Court also ruled that this is some kind of a problem which should be sorted out by the disciplinary authority of the institute. The students should not be under the constant apprehension of in 2001. Things moved like that. We have by that time committees, etc. But again, something happened in 2007. In 2007 again there was one more case, again from Kerala it came, and this case is known as University of Kerala versus Councils of Principals College. And in this case, they also came out that whatever, because by that time 6 years have passed. In 2001 was the last Supreme Court intervention in anti-ragging cases. Now about 6 years, nothing much has changed. Not many states have come up with their act, and Supreme Court in that case also told that no police intervention. It should be dealt by the institute itself, by the virtue of their own disciplinary authority. And now nothing moved. Things became bad to worse. And in this particular case, again another case in 2007, the Supreme Court came heavily upon these institutes, regulatory authorities, and wanted that there must be some regulation in place. And for the first time, the Supreme Court, this continued for 2 years, this particular case. Supreme Court wanted some kind of an expert opinion. and they engaged one Mr. Raghavan, if you would have heard the name, former CBI chief, who was actually the person who supervised the Rajiv Gandhi murder case and that conspiracy case. Mr. Raghavan is an eminent police officer, and Supreme Court wanted him to study and give a report actually what is happening in the ground. Why, in spite of the directive of the Supreme Court in 2001, nothing has changed in the field. This study is a very empirical study. For the first time, this committee has gone to many states and also visited the higher education institutes. And they have interacted with the students, they have interacted with all the stakeholders and came up with a very good report in 2008 or 9 maybe, after about 6-8 months. This report was given to the Supreme Court. After getting this report from Raghavan committee, the Supreme Court included the whole thing in the judgment, and the judgment came in 2009. In fact, this is the Supreme Court judgment on the basis of which the regulation of UGC has come up, and many other. For example, All India, this technical AICT, MCI, they came up with their regulations also after the ruling of the 2009 Supreme Court ruling. But in 2009, there was a significant shift from the earlier one, 2001. In 2001, the court was clear that there should not be any kind of a police intervention. But in 2009, probably Mr. Raghavan never also wanted too much of intervention, but he suggested that in his report, recommended in his report, that look, this has to be treated as an offense. If all the time you are mollycoddling the offending or the offenders, seniors who have indulged, and kind of mitigating it in the campus, probably this menace will continue. Some cases, certain cases, if it is revealing some kind of a cognizable offense, should be handled by the police, and this was accepted. That means while in 2001, on the basis of Supreme Court directive, we were more onto the preventive aspect of this thing. In 2009, this is more little proactive. In fact, Justice Arjit Prasad and Justice Ganguly, these two judges passed this decision. Both of them are from Odisha High Court. They went to the Supreme Court from Odisha High Court. And I was wondering, both the judges could have also had some kind of directive that the states which have not had special acts for ragging, anti-ragging, could have also legislated soon. That could have been also one of the directives. Nothing was there, but this judgment gave certain role to the district administration. For example, I do not know whether, sir, you will be able to let me know whether there is some kind of a district level committee in which the district magistrate and SP are also the members. There should be some kind of a local level in which the SHO of this area has to be a member. And the Supreme Court directive or ruling in 2009 says that if the SHO or the officer in charge of the police station, it is his responsibility. I do not know. It's very interesting. As if it is his responsibility to prevent any form of ragging in the institute under his jurisdiction. If this is under Jatani police station, I do not know. Or no, police station is what? Pipli. Okay. If under Pipli police station, that means as per the Supreme Court directive, it is the officer in charge of the Pipli police station who has also a responsibility to prevent, to ensure, it is mentioned ensure, any kind of ragging in that institute, which means by virtue of this, the police has some authority, probably, of course, with the information or with the approval or concurrence of the authority of the institutes, one can visit, and there is a responsibility now given to the SHO. But if I sum it up, whatever I told, Supreme Court intervened in two occasions, in 2001 and 2009. States have their own act also. By this time, probably about 10 to 12 states have their own act. About 18 to 20 have not their act. One of them is Odisha also. I'll come to that point. Odisha does not have a special act for the anti-ragging measures. Now coming to, these two Supreme Court decisions are very, I would say, landmark decisions on the basis of which lot of things have happened in the campuses. Like today, if you are here discussing about the matter, about a seminar, thanks to the Supreme Court directive. And also, of course, all the regulatory authorities like UGC, ICT, MCI, they all have to kind of have their own preventive measures and system in their respective jurisdiction. So because of that, probably we are here. Now, let me tell something about the, when we say that this is ragging, the topic you have asked me to, ragging a criminal offence. Criminal offence. What is criminal offence? You understand criminal offence. You know about a case of murder, you know about a rape, assault, attempt to murder, all these are criminal cases. But when you say criminal cases and offence, one has to be slightly, you should know the difference between the criminal case and offence. Ragging is a crime, there is no doubt about that. A crime is what? Which is probably revolting to the general conscience of the society. So that's a crime, any act or omission. Now, unless that crime becomes part of your statute and is penalized, it cannot be called an offence. So when so there are crimes also which may not have been categorized as offence. And if the crime is not categorized as offence, it is not punishable. So, for example, if I say, something like ragging, we can take. In Odisha, suppose, I'll say ragging. Ragging definition is not necessarily meaning about physical assault. A physical assault is an offence under the Indian Penal Code. But ragging also some kind of a mental torture. Ragging is also some kind of a, bullying. Ragging also, some kind of a practical joke which I do not like. It's insulting, it's humiliating. So, I cannot go to the police station people and say, this was some kind of a ragging, I felt humiliated. In fact, the law does not have such kind of a definition. That means this is not an offence. He would say, sorry sir, I cannot do anything beyond, humiliation and bullying, etc. If he is going to assault you, probably I can help you. That means you have to wait till assaulted, then you can register a police case. So the offence and crime is something like that. And that means there are certain acts which are offence in Indian Penal Code. For example, assault is offence. But now question is, ragging per se is not assault. Ragging means so many other things also. Unless the state makes it, penalize it, that act or omission, we cannot say that it is an offence. So when many states have, some states have there, about 12 states have their anti-ragging law, in which they have penalized ragging, and the definition of ragging also is it's a very expansive definition. It's not confined to the assault, physical assault or sexual assault. It is also some kind of a mental torment. It is also bullying. It also includes practical jokes, humiliating jokes also. But that is not there in our Indian Penal Code. So when I say that ragging is not an offence in the Indian law, I am right. That means throughout India it is not an offence. When I say ragging is an offence as per certain special acts of the states, yes, Maharashtra have there, Andhra Pradesh have there, they have made it an offence. It's a crime and offence in Maharashtra. It's a crime and offence in Andhra Pradesh, crime and offence in Himachal, crime and offence in Tamil Nadu, where they have had their own law. But as regards rest of the states, it's probably not. It's a crime. It's a crime, no doubt about that. but it's not an offense. That means it has not been penalized in the code or in the statute, many states. And if you ask me, Indian Penal Code, can it take care of all these things? To some extent, yes. When the things are beyond bullying or practical jokes or humiliation or insulting remarks, etc. Lewd remarks, yes. Assault, yes. Intimidation, yes. Then beyond that, suppose some kind of assault, and I am not going about the murder and attempt to murder. Too much of that. I wish nothing happens also, at least in our state. It's a peaceful state. And certain, IPC has about, I was having a look at that, about abatement to ragging, criminal conspiracy, unlawful assembly, rioting, violation of decency, injury to body, wrongful restraint, use of criminal force, extortion, assault, sexual offences, criminal intimidation, offence against property, attempt to commit any of these. These are all offences. So there are about more than a dozen such offences in the Indian Penal Code or Bharatiya Nyaya Samhita. But what about this mental thing? What about this humiliation? Indian Penal Code has not made them offences. Only if the state could have had some kind of act, then all these things, like definition, all of you know that definition. So ragging per se has been made an offence, and it is not exactly assault or maybe remarks, etc. Ragging has been defined in a broader term as per the Supreme Court rulings, and whoever does that, whoever abates that is an offender. And in Tamil Nadu it is 2 years. In Himachal, which is one of the latest, probably in 2012 they came out, and they have about 3 years and punishment. Here in Odisha, we do not have a specific law regarding measures against ragging, etc. Nevertheless, I would say, thanks to Macaulay, in the way the Indian Penal Code has been drafted, designed, legislated, it can take care of most of the definitions, whatever I see, overt acts as far as ragging is concerned. But again, I have a small, I would say rather anguish, I can say. Probably this was an opportunity. In this particular Indian Penal Code version of Bharatiya Nyaya Samhita, what has happened? Snatching has been made an offence. Snatching, you know that many of the girl students may have suffered also. Snatching some your chain or something like that, or your purse, probably in the lonely area you're going, that has been made an offence. Good, it should have been made an offence. The terrorism has been made an offence. It was there, of course, but it has become part of our this thing. Organized crimes, petty organized crimes, question paper leak has been made an offence. So when the lawmakers could go to this extent, question paper leakage is now an offence in the Indian Penal Code. Macaulay never thought that. Macaulay thought that everything will be fair in the Indian examination system. But now we saw that question paper leakage. So we wanted some kind of we made it an offence today. From 1st of July 2024, snatching is an offence. It was not there. A question paper leak is also an offence. So my anguish is, ragging should have been, an overarching in the Indian Penal Code or Bharatiya Nyaya Samhita, so that there was no need for any state to have their own act. Like about 10 to 12 states, they have their own act about anti-ragging measures. But nevertheless, I would rather, will be grateful to the Honorable Supreme Court for these 2 landmark judgments, and also all the regulatory authorities, including UGC, for having, following up the directive of 2009, I would say very studiously, complying those directives even today. And I am happy that, at least we have not heard of any major ragging incident from XIM University. And maybe your internal mechanism is also very strong, and also vigil is also strong. or maybe this the student, I would say the interaction, etc., has been good, as a result of which this kind of this overt act or this menace at least is not reported from this place. That's a good thing. Keep it up and have this good name also. You have a good name also throughout India now, and also in the state, of course, and also in India. So keep it up also. And I think I should stop here. I just thought to give you an overview by saying that it has not been made an offense in the Indian law. Do not get don't get scared, because the law is enough. If I say this Nyaya Samhita, Indian Penal Code, I read it out about 13 or 14, so they are enough to take care of any kind of overt form of ragging. I'd be happy if you ask me a few questions, and I stop here. No, if they ask any question, I can answer from here. If you want that, no, enough is enough, sir, it's 4 o'clock. Sorry? Okay, please come.
Thank you, Dr. Mohanty, for your invaluable contribution in leading such an insightful and engaging session. Your expertise and valuable perspectives have truly enriched our understanding, and we are deeply appreciative of the time and effort you have dedicated to being here with us today. We now open the floor for questions. If you have any questions for Dr. Satyajit Mohanty regarding the topics discussed today, this is your opportunity to engage directly. Feel free to raise your hand and we'll bring a microphone to you. Okay, we will carry on. Before we conclude this session, I would like to invite the coordinator of the Anti-Ragging Squad of XIM University, Mr. Prashant Mahapatra, to deliver the vote of thanks.
Good afternoon, one and all. As we conclude the significant orientation and seminar on the topic, ragging a criminal offence, it is my privilege to extend a vote of thanks to those who have made this event possible and successful. First and foremost, we extend our deepest gratitude to our esteemed Chief Guest, Dr. Satyajit Mohanty, IPS retired. Your presence and insightful addresses have provided us with a profound understanding of the importance of upholding anti-ragging measures. Your experience as the former chairman of the Odisha Public Service Commission and DGP of Odisha brings a wealth of knowledge and that has greatly enriched our event. We are also grateful to Professor V. Vijay Kumar, Dean of the School of Communication and Coordinator of the Anti-Ragging Cell at XIM University. Your dedication and leadership in coordinating the crucial program reflect your unwavering commitment to creating a safe and respectful environment for all students. We thank all the faculty members present here. We thank Professor L.K. Jena, Professor Sasikant Khuntia, coordinators of the Student Affairs for PG program, and Professor Lodus Vijayan, our coordinator of the Students Affairs of UG students, for your contribution in moderating student activities. A special thanks goes to the resident management team and the anti-ragging squad members for their vigilance and active participation in enforcing the guidelines we have discussed today. Your role in mentoring a safe and supporting environment cannot be overstated. We also acknowledge the SECPG and SSC UG for their active engagement and contribution in today's program. To our students, we express our sincere appreciation for your patience and cooperation. Your attention and participation in today's session are crucial. We are also thankful to all the IT team and the media team, photographers from the School of Communications for their contribution for the program. The administrative team deserves our thanks for their behind-the-scenes efforts that have facilitated the smooth execution of today's program. Finally, we extend our sincere gratitude to Father Anthony Arugari, the Vice Chancellor, and Father S. Anthony Raj, the Registrar of XIM University, for the uninterrupted encouragement and support in organizing this event. We deeply appreciate your commitment to the students' welfare and well-being. In conclusion, today's orientation has been a testament to our collective commitment to combating ragging and fostering a positive and respectful campus environment. Thank you all for your contribution and dedication.
With that, we conclude today's session. Thank you all for being here and contributing to this meaningful session. We look forward to your continued engagement and participation in future events. Wishing you all a pleasant and restful evening.